any on.
If the defense had raised it first and had decided at that point, looked into the issues of Evidence Rule 403 and 404 and the implications that would be triggered by bringing it up themselves, well, then certainly the state has a right to bring that in.
Well, it wouldn't even be necessary, would it, for the defendant to raise it? Just the testimony of the victim, and then probably the defense would counter that, and then in rebuttal it would be permissible to put on expert testimony about the battered woman syndrome.
Again, based upon precedent and based upon due process and fair trial implications, I believe that the defense needs to bring that up in matters of self-defense. Again, we are far outside the limitations.
Because that's what we said in State versus Cost.
That's correct.
Just so I understand the timing, based on the Chief's question, the witness testified, then defense counsel cross-examined her.
Correct.
And then the doctor was put on the stand.
Correct.
And then the cross-examination did bring out credibility issues of why she returned to the relationship and means to escape.
As it usually does.
How did she respond to those questions as to why she didn't leave?
She spoke of fear and other history and prior experiences with the appellant, as for reasons.
So in response to the questions of defense counsel, the victim testified about prior incidents with this defendant.
But before that, it was also addressed in the state's case in chief by the prosecutor. In direct testimony, it was also raised there, prior instances. It was then.
That's what I'm trying to get at is the prejudice that would inure from letting battered woman syndrome testimony from an expert into trial in the state's case in chief would be that other incidents of the defendant's behavior would infect the jury, which may not be at issue at that trial.
That's correct.
But you're telling us that that had already been disclosed to the jury on in response to cross-examination by defense counsel.
I'm sorry if I was unclear. It was elicited in the state's case in chief during direct testimony by the prosecutor in that case. The defense lawyers thereafter had to address those issues again. So it came up again, but it did not originate during cross-examination.
So in response to the cross-examination as to why she didn't leave, did the question of why she didn't leave come up in the state's case in chief on direct or only on cross?
Your Honor, frankly, I don't recall exactly where it came up in the transcript, so I don't want to mislead the court and just throw out an answer.
Mr. Friedman, go ahead.
Counsel, the briefs talk about the other states that accept the application of battered women's syndrome to speaking about a victim's state of mind and so on. And in some of those cases, it seems that the expert is allowed to testify to the general explanation of the syndrome, but is not able to give an opinion or relate it to the facts of the pertinent case. What happened exactly in this situation? What did the expert do, in your view?
Thank you, Your Honor. In this case, Your Honor, Dr. Eisenberg had given, after he had given his credentials, had given his experiences in court, went beyond the cases referenced, which you referenced in the brief, and very quickly, there are 12 states that we see throughout all these briefs that have now allowed it with conditions. And as you recognize, only general conditions are allowed. There can be no reference to the case at hand. There never can be an actual diagnosis. And typically we find in these other cases throughout the state that there is no knowledge of the case by the experts. To answer your question directly, Dr. Eisenberg testified that he was familiar with the case at page 531 of the transcript. He stated, quote, "As I understand the facts of the case in front of us and from my review of the records, it is very consistent with what we see in battered woman syndrome." He went further to specifically make a diagnosis of post-traumatic stress disorder secondary to battered woman syndrome at page 545. He responded affirmatively to the state's question when asked by the state whether, in his opinion, he saw features of battered woman syndrome. He stated what he based his decision on, and that was prior therapy records, recorded information generated by the victim, documents left at the victim's workplace, police reports, letters from appellant to the victim, and personal examination conducted of the victim, including an MMPI exam that he personally did at page 538 of the transcript. He acknowledged familiarity with specific instances. For example, on March 31st, he stated that he was aware of all the facts on that particular day. The prosecutor utilized the victim's name and the specific facts, and the doctor stated, quote, at page 563 of the transcript, at that time she was fearful for her life. So this goes so far beyond general theories of battered woman syndrome. We're now actually trying to speak to a victim's state of mind and answer your question. I've reserved 3 minutes, and I'm under that now, but if there are any further questions.
I have a legal question for you that has not been developed, it seems to me, by counsel. It seems to be a very important legal question, is that when we decided the first battered woman syndrome case, there was common law. There was no statute. General Assembly, of course, has adopted .06b, which is very limited. They've codified the common law, and it doesn't seem to apply here. I mean, it doesn't seem to authorize the use of battered woman syndrome in this situation as it was used. It's very limited. What's our authority to go beyond when the General Assembly has codified common law? What's our authority to go beyond the plain words of the statute and say, well, we as we did in Cost somewhat, we think it could be broader. Now we've got a statute which we didn't have in the first case, so we don't have the latitude, do we, to, I'll ask opposing counsel that same question. It's a more difficult question for them, but what is your thought? There's a whole body of jurisprudence in this country about the tension between common law and statutory law. When legislatures codify common law, what's the authority then of a court to go beyond that codification?
Very good. In answer to that question, I think that we see it in this court's decision, State versus Sally, where we utilized the statute that was present at the time in 1998. The perfect example to respond to your question, Your Honor, is one of the cases that was cited by appellee, and that was People versus Gadlin. That was a California case from 2000. They also had